Hi there and welcome back to Employment Hour in 30. If you're just joining us for the first time, we talk about employment law, your employment rights, your job, your boss. Maybe you are the boss. All kinds of things happening on the show again today. I'm John Scholes, your host, co-host Lior Samfiru from the Samfiru Tumarkin law firm here. Going to educate you, get education about what you should be knowing when it comes to workplace rights and things you need to know. There's an easy way to contact us any week, by the way. It is simply help@employmentlawyer.ca or 1-855-821-5900. We will get to the talk of reprisals, a word some people may not even know what it means. We'll get to that a little later on the show, talk about what is a temporary layoff. And of course, we always start, my brother, with the week that was, some things that have been happening in your office. So take it away.
As always, John, I had the privilege this week, as every week I do, to speak with a lot of people, answer a lot of questions, and hopefully help people alleviate some of the concerns that they have about their workplace problems. And that is really a privilege that I have, that I get to take people that are in a difficult situation and hopefully make it a bit easier for them, make it a bit better, take away some of those concerns. And let's face it, if you're facing a problem at work, something happened, it's going to impact you, not just at work. You're probably going to take it home with you. It's going to impact how you deal with your family. It may impact your health. I've seen it time and time again. That's why I think it's so important not to let these things fester. If you're dealing with a workplace problem, if there's something going on there that makes your life difficult, your boss did something, said something, you're being threatened, maybe discriminated against, or if you lost your job, let's speak. Now, when you contact me, we're not going to put you on air, we're not going to put you on TV, we'll talk to me privately, but take the opportunity to speak to me and let's resolve those problems. And I always like to start off here on the show, John, talking about a situation that came across my desk over the past few days. So I spoke with a woman who was working for a very small company. There were 3 employees plus the owner of the company. Well, I guess the owner of the company, I don't know, either took a liking to her or maybe he was just not very bright, but he was saying completely inappropriate things. He was complimenting her looks, complimenting her legs, commenting about what she was wearing, whether it's revealing or not, that she should wear things that are more revealing because she has a good figure.
Settle down.
Settle down and have some common sense. This is not the 1800s. So she obviously was very uncomfortable, but she was also intimidated by this person. She was not necessarily comfortable going to him and saying, "Hey, buddy, stop doing that." So she called me. She was very, very upset. Again, she's a younger lady, and she wanted to know, what do I do in this situation? So the first thing I told her to do is, starting now, I want you to keep a log. I want you to keep a log of when these things happen and what it says. You can have a little notebook, a journal, whatever it is, saying, on September 25th, he said this to me. On October 17th, he said this. Now, once you have a few of these things, 3 or 4 of them, then we are in a position to treat that as 2 things. Number one is a human rights issue, because clearly this is a human rights violation. No one should be subjected to these sexual comments, but also as a constructive dismissal. We can get her out of there with compensation because she doesn't have to just take it. And I wanted to talk here about this. I wanted to mention it, that if you're dealing with harassment or sexual harassment or discrimination, any situation where someone is mistreating you, putting you in an uncomfortable situation, you don't have to just take that. You have options. And as long as you can establish and prove what's been happening, you may be able to leave. You may be able to treat that as a termination of your employment and leave with your severance, potentially also pursue this as a human rights matter. So bottom line is, don't just take it. That's unacceptable, that type of conduct. We all have rights in the workplace, men and women, it's the same thing. And if anyone violates those rights, let's speak, call me, email me, and we can fix that problem.
As far as keeping records, that goes not only in this case, I guess, for everything in the employment umbrella. Always keep records of everything, especially if there's a problem. The records that she's keeping, when she's making note of these incidents that happen, does she have to give them to him and say, just so you're aware? Have them signed, or can she just keep them private?
Yeah, it's an interesting situation because it is the boss, and
right.
I think if she went to him, it's going to make her life even more difficult there. So I would say in this situation, don't. You can keep those records for yourself, but make sure they're contemporaneous. Make sure you keep them when the events actually happen. So don't wait 3 weeks and then say 3 weeks ago, here's what happened. So if something happened today, he said something, he did something, write it down. Write it for yourself. Don't show it to anyone. When the time comes, you'll have that credibility because you put that in writing. So it's very important to keep notes, keep records. Don't just rely on your memory.
So legally, she can just keep it to herself?
She absolutely can, and she should.
Right. EmploymentHourTV.ca is a great resource for all things about the show. It is also a place to find where you can catch our radio show, which we have been doing for almost 6 years here. You want to find out a station where you can catch that. That is the place to go. And again, EmploymentHourTV.ca. And from the radio show, on this show, we like to play some phone calls back and get your opinion on them and reflect on them.
I've been employed for 8.5 years for this one company. I'm 60 years old while I was a mechanic. Without any kind of warning, notice, I was called into an office. Papers were shoved in front of my face and said, "You're fired." I'm just wondering, he gave me a very small severance. I was kind of intimidated at the time.
Sure.
When this happened, and it shocked the hell out of me. Didn't sign any paperwork at all. And I was just wondering if there's any legal aspect, take that further to see if there's any more compensation I can get out of that.
Yeah, and what he's describing here, John, is a very common situation. So most people, when they're let go, they're not expecting it. They're probably going into work thinking today's going to be a day like every other day, and they show up, they're called into a meeting, papers are shoved in front of their face, today's your last day, here's what we're offering you. There's this implied pressure to sign, and people oftentimes are not thinking clearly, and in that weakened state, they may sign off on that offer. I'm glad that he didn't. Yeah. And the reason he didn't is because he's owed a lot more. I mean, again, I don't know exactly what he's owed, but if a company's going to treat him that way, the chances of them actually giving him proper severance are not good. So he's owed what he's owed. Let's talk about that. Let's talk about what he's owed. So his entitlements are based on 3 factors: his age, his position, and the length of his employment. Now, I can tell you right now how much he's owed, but let's actually plug his information into the severancepaycalculator.com website so that everyone can see how it's done. People can do that themselves. So he's in a technical job, 8 years of employment, 60 years old. Severance Calculator correctly calculates that he's owed somewhere north of 12 months' pay, a year's pay. So that's the severance that he's owed. He said they give him something nominal, something minuscule, so it's probably not 12 months' pay. That is what he's owed. Anything less than that would be a wrongful dismissal. So now that we know that, we can help him get that. That's not difficult to get what you're owed. Oftentimes a letter is all that's required here. So he did the right thing by not signing. He should reach out to me and we can resolve it. And the same thing applies to you at home watching right now. If you're let go, if you've been called into the meeting, you've been shoved papers in front of your face, call me or go to severancepaycalculator.com to find out what you're owed. Never ever sign without doing that.
You know better, I know better, our viewers know better that's not appropriate. He's being shortchanged in a big way. Why do companies generally keep doing this?
Well, because most people, John, don't know better. Most people will accept without even thinking about it because they're intimidated, they don't know better, they assume that it's fair. Oh, and in some situations, the company itself may not know better. The company itself may not be sophisticated or educated on its own obligations. So you can never, ever assume that the company knows what it's doing, that it's doing the right thing. I can tell you 90% of the time that's not the case.
You know, and I'm thinking with some companies, even if they do have a somewhat sophisticated HR department, they do know better. You know, they're playing the odds. Out of 100 employees that they let go, maybe 5% will wise up and seek, call you or say, hey, this isn't enough, and I know it's not.
It's pretty good odds, right? Yeah. Pretty good odds for the company, which is why what we're doing here is we're trying to even out that playing field a bit. So if those watching right now, be the 5% that actually know what they're owed. Be that 5% that don't accept $50,000 less than what you're owed. Terrible situation, and tell others. Let's increase that 5% to 10, to 20, to 50, so that people actually know that they have rights and can stand up for those rights.
Again, employmenthourtv.ca is a great resource to find where you can catch our radio show, our weekly radio show. We'll get another call from that show right now.
I worked in a hospital as a therapist, and the population can be very angry, sometimes bullying and emotionally abusive.
You're talking patients now.
Yes, and I'm wondering, given the nature of the population and my work, what am I expected to tolerate? Is it just part of my job, or what is my right? Do I just take it?
It is a very difficult situation, especially in a hospital environment where you're going to be dealing with people that are not necessarily in the epitome of health, and they may not necessarily be thinking straight. They may have mental health issues. Sure. They may impact their behavior. And oftentimes that translates into abuse. So let's be very clear. Hospital or any other workplace, you should not, as an employee, have to tolerate abuse. You should not. Absolutely not. So what does that mean and for her? If she's being abused in that situation, she has to tell her boss, her HR manager, whoever runs that place, because they can't allow that patient to continue being there if they're abusive. They may have to tell the family, sorry, we can't care for this individual because he or she is abusive. They may need to go to a special facility for that. You have a right not to be in an abusive work situation, whether it's the boss, a coworker that's abusive, or whether it's a customer, a client. You have a right to be safe in the workplace. You have a right to work in a respectful environment. And when those lines are crossed, you should stand up for your rights. And if nothing is done, that could be a constructive dismissal. You may be able to treat your employment as being terminated and leave with your full severance.
A call anytime, 1-855-821-5900, help at theemploymentlawyer.ca. That is the way you want to contact Lior or a member of his team for that matter. Reprisals, I want to get into this topic. First of all, everything you need to know about a reprisal. What is it?
A reprisal is a situation, John, where you're being punished for standing up for your rights. And that is something that is illegal. Our legal system, when it comes to employment law, protects employees and gives the employees the rights and the power to pursue their legal rights. And what it means is if an employer says, wait a second, you're asking about your overtime or you're demanding overtime, just as an example, then we're going to punish you. We're going to let you go for that. We don't like people that are the squeaky wheels here.
Rocking the boat.
Rocking the boat too much. In that situation, that's what we call a reprisal. That's illegal. You can't be punished. So what we want to talk about are situations where you may get punished for your for standing up for your rights, because the message that I want to send here is that everyone watching out there should feel comfortable knowing that the law protects you and gives you the right and the power to pursue your rights, to stand up for your rights, and you shouldn't have to do that being concerned that someone's going to punish you for doing that.
You mentioned overtime. What are some other examples of a reprisal?
So really, it's a very broad term. Anytime you stand up for your rights and you're being punished for it is a reprisal. So maybe you're asking about your overtime or your vacation pay or your statutory holiday pay. Maybe you don't feel you've gotten your minimum wage calculated properly. That's one aspect of reprisal. Another aspect of a reprisal could be if you're, let's say, complaining about harassment. And your boss punishes you for that. Maybe they ostracize you or let you go because you had the audacity to complain about harassment. That's a reprisal. That's illegal. Or maybe you've complained about an unsafe work environment. Let's say the machine you're working on is unsafe and you're complaining about it. You have a right to refuse that work. And if anyone punishes you for refusing that work, that's a reprisal. That's illegal. Your employer would have done something that the law says they cannot do. So anytime you're pursuing, asking questions, or trying to enforce your legal rights and you get punished, that's illegal. It's a reprisal.
If you think you're owed something at that point, what do you have to do?
Well, I mean, it could be as simple as starting with talking with your employer and saying, I feel that, or I believe that I'm owed overtime, and here's why I think that. And let your employer tell you yes or no, and obviously if you don't agree, you can escalate it. But I always would suggest starting with your employer, talking to them about it, knowing, of course, that they can't do anything to you. And what's important, John, is even if you're wrong, even if you think you're owed overtime, but it turns out you're not. Even if you think you're owed statutory holiday pay, and it turns out you're not. But by raising those issues, you cannot be punished, even if you're wrong. So what does that mean? You can talk to your boss. You can even go file a complaint with the Ministry of Labor. You can retain me to help you get those rights. And your boss cannot punish you in any way for doing those things. You have a right to pursue them, and anything that punishes you for that is illegal.
You mentioned starting a claim with the Ministry of Labor. This is, as we always like to point out every so often, every few weeks, that this is one of those situations where it is okay to go to the Ministry of Labor, right? Or you should.
Well, you absolutely should. I'll make it very simple. The only time you should not go to the Ministry of Labor is if you lost your job or are concerned about losing your job. The Ministry of Labor cannot help you get your termination entitlements, not your full entitlements. They can help you with respect to overtime and vacation pay and statutory holiday pay. No problem. They can help you with that. And if you think you're owed that, it's a perfectly viable thing to do, to go to the Ministry of Labor and say, help me, knowing, of course, that you can't be punished for that. You cannot be disciplined for it. You can't be ostracized, demoted, pay reduced. None of that can happen to you if you do that.
Help at employmentlawyer.ca or 1-855-821-5900 is the contact. Okay, reprisal, get back to that. So an employee feels that they've been punished for something like that. What's the first steps they should do?
If you feel that you raised an issue with them and they punish you for raising it, they say, well, employer, I've been working more than 44 hours a week. You haven't been paying me overtime. I want you to pay me overtime. So they say, you're not a team. You're not a team player. You're rocking the boat, as you said. So we're going to punish you. We're going to move you location or give you less hours or whatever it is. Well, if that's the case, that reprisal, number one, is illegal. So you may get compensation just for having the employer behave in this way. But it also may mean that could be a constructive dismissal. The fact that your employer punished you for having the audacity to stand up for your rights is illegal, and that may mean you can leave there with severance. So if you feel you're being mistreated because you stood up for your rights, call me. Let's talk about that. Let's talk about how to best pursue this. Do we push back against your employer? I can help with that. Do we remove you from that workplace as a constructive dismissal? Bottom line is, don't just grin and bear it. Don't just take it because what the employer is doing is illegal.
So when you say leave with severance, full severance, or is it a portion of, or?
full severance,
It is?
Johnny.
Wow.
Yeah, if a constructive dismissal because of a reprisal, just like with any other dismissal, you get your full severance based on your age, position, and length of employment. And if you ever want to find out how much that is, you can do that right now, severancepaycalculator.com.
And any human rights damages would be on top of your severance as well?
So if this touches on a human rights issue,
Right.
maybe you feel that someone is mistreating you because of your race or ethnicity, and you raise that and you're being punished for it, then that's a human rights violation.
Wow.
And that will be over and above reprisal damages. It will be over and above wrongful dismissal and severance damages. That's a separate issue, and absolutely, people should know that the Human Rights Code also protects you from pursuing your rights, asking questions about your rights, and of course, standing up for them.
Lots more to come. In fact, we'll get to the truth about temporary layoffs, and we'll dip back into the severance pay calculator after a short break. 1-855-821-5900 and help at employmentlawyer.ca. Employment Hour in 30 continues. Hang on.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back. Employment Hour in 30. You want to contact Lior, a member of his team, 1-855-821-5900, or simply help at employmentlawyer.ca. We talked about it in the first segment. It's a handy tool. Over 500,000, and I mean 500,000 people have used it, and as we say each week, had their eyes opened. We're talking about the Severance Pay Calculator. You can check it out now as we get into it, severancepaycalculator.com. Give me some details, pal.
I realized early on in my career, John, that people, for some reason that I don't understand, don't like lawyers. They don't like lawyers. Yeah.
Shocking.
Shocking. They don't like lawyers. And because of that, people oftentimes would do whatever they can to avoid contacting a lawyer. And if that meant accepting severance that's inadequate just not to call a lawyer, they would do that. And in doing that, it was wrong not to call a lawyer. They would walk away from tens of thousands of dollars. So I thought to myself, well, how do I make it easier for people to get that information, to find out how much severance they should be getting even without calling a lawyer, even without calling me? Well, that's where the Severance Pay Calculator website came out of. So severancepaycalculator.com is the website you can go to anytime to find out how much severance you're owed, the real dollar amount, what the law says you should have, your full entitlements. Now, when you go to severancepaycalculator.com, you're going to be asked a few questions. What is your age? How long you've worked for the company? What type of job that you have? And when you answer those questions, you're going to find out whether you're owed 18-month severance, 24-month severance, 2 months, anything else in between. It's easy. It's anonymous. No one asks you for your name or your company's name. It's completely free. There's nowhere to input your credit card. There's no strings attached. It's just there for your information. You can use that if your mother lost her job and you want to find out how much she is owed. So check out severancepaycalculator.com right now. I call this the Severance Pay Calculator Challenge. If you think you know how much you're owed, write that number down. Go to severancepaycalculator.com right now, use it, and find out if you're right. I bet you in most cases you're going to be far, far off. You're not even going to be close. There's no bug in the system. It works well. severancepaycalculator.com, the very first place you go to if you lost your job.
And you know that number is going to vary for, depending, as you said, age, employment, what your position is. But what is not going to vary is the fact that the number will be shocking compared to what you think it should be, or what you've been given by an employer, right?
When you look at it and you see, wait a second, this is 5 times what my employer's offered me. You may think, well, there's a bug in the system. You may take your phone and shake it and see if it works better the second time. No, there's no bug in the system. In most cases, you're owed a lot more than what your employer is offering you. It's just a fact. That's why it's so good to use severancepaycalculator.com.
Put it to a test. I'll give you a scenario here. 41-year-old Jamie has been with the company for about 2 years. On Monday, she was temporarily laid off. We'll get to that in a minute. With a return to work date to be determined. If I'm not ultimately recalled, am I eligible for a severance package?
Well, let's talk about the temporary layoff first. Her question is, if they don't call me back, am I eligible for a severance package? The answer is absolutely, but it's even more than that. You are eligible for a severance package now. Right now. you don't actually have to wait to be called back or not to be called back, because the temporary layoff in and of itself is a termination in most cases. Your employer does not have a right to lay you off temporarily, and if they do, you have the right to treat that as a termination right now, today, and get your full severance. So if you've been laid off temporarily, call me. You don't want to just sit at home and accept it. If you accept it, you give them the right to do it again and again in the future. Bad situation. So let's get down to the numbers, though. Let's see how much is Jamie actually owed. So rather than just tell you, let's use the severancepaycalculator.com website that I've been telling you about. Let's plug Jamie's information and see how much severance she's owed. So I don't know exactly her position. I picked supervisor, sounds right. 2 years of employment, age of 41. Well, Severance Calculator correctly says after 2 years she gets anywhere from 4 to 6 months of severance. Now, she may be offered 2 weeks or 3 weeks or 4 weeks where she's owed potentially as much as 6 months' pay. That's how it works. So you just saw an example right now how the severancepaycalculator.com website works. Check it out. You could do the same thing even if you haven't lost your job, even if you're just curious. Check it out right now. And if you want to, there's a little green button there you can press to contact me if you want only, so that I can help you get what you're owed.
I know it's correct. The number is correct, but a lot of viewers are going to be thinking, that seems like a lot for a person that's only been employed for 2 years at 40. That would seem consistent with somebody who's been around the job for 9 years. Why is that?
Well, the reason for that is short service employees are treated disproportionately better when it comes to severance than long service employees. So you may have an employee that's worked for a year and may be owed 6 months severance. In fact, you may have an employee that's worked for 4 months and may be owed 6 months severance if they're senior enough and older.
Right.
So short service does not mean little severance. In fact, the opposite is true.
1-855-821-5900, help@employmentlawyer.ca. That is the place to reach out and contact Lior. And employmenthourtv.ca, again, a great resource to find where you can catch our radio show, or weekly radio show. Call into that show if you'd like, and we get some calls from the show, and we play them back here on the TV show to let you hear. So we'll get another one.
I work at a call center. We're doing sales, and I'm not meeting sales targets. They keep calling me up and saying, you're not saying, let's get the credit check done. I try on most of the calls there, but a lot of the calls I have are like people calling in, they're angry because they didn't get something they were promised. At this point here, they're like, we've talked in the past, your next step is a 60-day improvement or else you're out. Do I have any recourse on that, or is it, that's it, I'm done there?
Common call with salespeople.
Very common with salespeople and others. At the end of the day, when you have a job, all you could do is your best. And there's other factors oftentimes you can't control. Sometimes you may have an unhappy customer even though you've done everything right. And there's not much you could do about that. So if they're complaining about what he does and how he's doing things, and he doesn't feel that that's a fair complaint, I want him to say so, and I want him to say so in writing. I want him to send an email to his employer telling him, here's what's actually happening, here's what I'm trying to do, and here's the pushback that I'm getting, and here's why I can't necessarily do it the way you want me to do. Do that. Now, if the company ultimately lets him go, it's not going to be a cause termination. Not even close. They would have to show that he's going out of his way to do it wrong, that he's essentially doing it wrong deliberately, that he's that bad. Not that he's trying to do his best, it's just not working out. That's never cause. Remember, it's always difficult to terminate for cause. It's reserved for the worst offenders. And just because you did something wrong, or because your performance wasn't exactly at the level that your employer wanted it, does not mean that there's cause to let you go. In most cases, there isn't. And if you're let go in that situation, you're owed your full severance. You could, of course, go to severancepaycalculator.com to find out how much that is. So this situation with the salesperson, that's not cause. You should respond to them. And if he is let go, to call me.
Coming up on the show after a short break, the choice between severance or another job. We'll get to that. 1-855-821-5900. Help@employmentlawyer.ca. This is Employment Hour in 30. Hang on.
Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back. Employment Hour in 30. John Scholes, Lior Samfiru, educating you on your employment rights in the workplace. 1-855-821-5900. Help at employmentlawyer.ca is the email. You can go to employmenthourtv.ca to find, as I mentioned throughout the show, the place to find where we host our weekly radio shows for, I think we're coming up on 6 years. We've been doing that all week long. Of course, we got a ton of phone calls on the show. Some of them are very interesting, and it's key knowledge. We're going to play another one back, and I know you want to comment on it, Lior.
My mother, actually, she's 1 month away from her 35th anniversary in her career. The store she's working at right now is closing. I offered her the opportunity to go and bump into another store, or you can take this package. The packages that are being offered to senior staff today are considerably different, much different than packages that were offered to other staff who retired, let's say, a couple of years ago.
No, 35 years.
35 years is a long time. So she's been told you have two options in front of you.
Yep.
You can switch to another store, or you can get your severance. So obviously she can make that personal decision as to what's better for her, the other store or severance. It may be that the other store is convenient, it's a good job, the hours are good. Right. If it's not good, then severance makes a lot more sense. So the first thing is to determine what is best for her. Does she want to continue working at the other store? Because she doesn't have to. She can treat that, she can simply get her severance. The real question is how much severance. Now, in saying that, the caller said that the severance they're offering her is different or not as good as what other people have been offered in the past. That ultimately doesn't matter, okay? What they offered, whether they were generous or not generous in the past, doesn't impact her. Her entitlements are her own, and they're based on her age, her position, and the length of her employment. So after 35 years, there's really only one number. She's going to be able to right around 24 months' pay. But let's still, for everyone at home and for her, let's go to severancepaycalculator.com and input her information so that people see how that works and how we got to the 24 months. So 35 years of service, I'm going to say in a sales position. She's his mother, so maybe she's in her 60s. I put that information in the Severance Pay Calculator. And as you can see right at the bottom there, Severance Pay Calculator, ta-da, shows 24 months pay. So that's what she's owed. Whether or not they were more generous or less generous in the past with other employees doesn't matter. If in the past they were offering 12 months or 6 months, none of that matters. Yep. She's owed 24 months pay. She should get that. And if she decides she doesn't want to take that other job, but she doesn't have to, she can get that severance. And if it's less than 24 months, she should reach out to me, call or email, and I'll help her make sure that she gets the full 24 months.
Another good resource is terminationquestions.com. I know, Lior, you personally and your staff answer questions on this website. When you just type them in there, chances are it's been asked already, so there will be an answer, a drop-down menu. Some of them come up, though, and I know you want to comment on this one. We pulled this before the show, and that was thought it was interesting. It says, I was let go 3 months into my maternity leave. I don't want to be paid my severance now because I'm receiving benefits through EI. What do I do?
Well, there's a first question that I have. Why are you being let go 3 months into your maternity leave? Because presumably you have another 9 months, maybe more, to go before you're coming back to work. So why is your employer deciding now that 9 months from now they don't have a job for you? Mm-hmm. Their obligation is to take you back when your maternity leave ends. And they can't say today that they're not going to need you in 9 months. Maybe they don't need you today.
They can't crystal ball it.
They don't. They can't. Then 9 months from now, they may be desperate for someone like you. So the very fact that they are letting her go with 9 months more to go is a problem. That could be a human rights violation. It could be a violation of the Employment Standards Act. In other words, it's illegal, irrespective of the severance. So the first thing I would want to understand is that. Now, in terms of payment, yes, she can absolutely arrange to get that paid at the end of her maternity leave, so it doesn't impact her. Right. Bottom line is there's a lot to discuss here, and I'd want her to give me a call. And remember, if you're let go while on maternity leave, you have rights. Your employer shouldn't do anything, shouldn't let you go, mistreat you, change your job. And if they do that, that could be a human rights violation. That's a serious thing. The law takes that very seriously. You really need to reach out to me then.
Don't mess with mama.
Never.
It's been like that since day one. Right? Don't mess with mama. We're done for another week. You want to reach out and contact Lior, member of the team. You have questions on your own. 1-855-821-5900. There is also help at employmentlawyer.ca and employmenthourtv.ca. That, again, is where you can find the weekly radio show and much more information. Hope you enjoyed the show. We'll be back with another episode of Employment Hour in 30 very soon.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.